Retired Dr. Besigye, Hajobedi Lutale, and Captain Ora Oyadenish are facing charges of treason and misprision of treason. The case is being heard by Judge Emmanuel Baguma at High Court Criminal Division in Kampala. When proceedings began, Judge Emmanuel Baguma asked the accused persons to address court on their legal representation as directed during the previous court sitting. While Captain Ola Oyadenish accepted to be represented by state brief lawyers, Dr. Besigye and Hajobedi Lutale declined, asking for more time to screen 227 lawyers from a list of 786 presented lawyers.
I will start with A1 to give the explanation of the first choice of your lawyers.
Good afternoon, Mr. Judge. When we were last in court on the 15th of this month, on the 15th, that's when we were last here. It's true that we are given those three approaches to solving our legal representation challenges. As we had chosen had made problems that would be resolved by our application number 248, which that sitting indicated the deputy registrar would communicate to us its fate. The deputy registrar did communicate to us the effect that the application had been assigned Justice Simon Peter Chinole by the principal judge. He attached directions that had been issued by the said Justice Simon Peter Chinole regarding the disposal of that application. Which gave dates for the various activities in disposal of the application. And he indicated he would be issuing his ruling in the application on the 13th of August. Considering that we had challenges for managing that particular application from prison, we are also in the process getting seeking assistance of some lawyers to help us. So that application is now on course. If it is successfully resolved as we hope it will, then the question of state-funded representation will not arise. Regarding the selection of state-funded lawyers, we confirmed to court last time that we had received the roll advocates on state funded representation. Of 786 advocates. And considering the third option you are talking about, the appointment of these three, I asked a specific question. It meant that we were now represented since they were introduced as having been appointed. Because that would conflict with number 2 of our own selection amongst the row of lawyers. Cannot be selecting and others are already appointed.
Have you selected?
I'm coming. I'm just talking about what to select from.
Yes.
Because I asked about these three, and you said
that is the third option.
I'm bringing it up in the second because I asked whether we are now represented.
I'm saying this is the third option. Let me get your response and the selection of your choice. Then we will come to the third.
That's exactly what I'm doing.
Yeah.
I'm only saying that when I asked whether we are now represented, you said no. They can send us their CVs. The three can send us their CVs so that they are considered alongside all the others in our selection. Indeed, their CVs were sent to us. We have since reduced the numbers of lawyers to select from. 780, 227, those who are in Kampala.
And now reduced how many?
227 state-funded lawyers who practice in Kampala itself. We have eliminated all those who are out country. So we asked our friends and relatives to contact these 227. We equally receive their CVs. To indeed consider them alongside the three that we received earlier. People have written CVs that simply talk about their qualifications.
Those 227.
Yeah, the ones we haven't received from all the 227, but the ones we have received, including the ones of the 3 here, they basically talk about their qualifications. And the firms they have worked with, the legal firms they have worked with. But nothing to do with the cases they have handled that would guide us as to their competencies relevant to our case. Of these 3, indeed, it was only Sylvia Namaweje whose CV touches on that, on cases she has handled. All the others talk, I have a certificate in the out-of-court settlement, I have a certificate. In pre-bargaining, I have a certificate. In this and that, he worked in this firm, but nothing relating to the expertise and experience of representation of cases like the one of the face. As I pointed out the last appearance, the charges we face are some of the gravest charges one can face, and complex in nature. And that's why we are making every effort to select advocates that would be comfortable and equal to the task.
Besigye also asked court to halt the proceedings pending a ruling by Justice Peter Chinobe on issues relating to their legal representation. However, the prosecution opposed all the prayers.
But we have not concluded. This process yet. And we were shocked indeed when we were informed that the 3 lawyers were in Ruzira to meet us wanted to receive our disclosures so that we discuss them. And we thought there was clearly a misunderstanding. So, Mr. Judge, there are two things now. One, the resolution of our application 248, which should resolve our legal representation challenge conclusively. And which is clearly our preferred option. We selected those lawyers very deliberately. They were doing a good job until they were interfered with. We believe that it's our fundamental right to be represented by lawyers of our own choice, where we can. Court gives us time to resolve that application before reverting the other options. But should there be the unlikely event, a persisting problem of legal representation, as I have said, sir, we are advanced in our process of selection from the role that we were given. We believe that maybe in another 1 week we will be able to identify the specific names we are comfortable with.
Three is willing, has agreed to proceed with the 3 state brief lawyers who were selected by this honorable court. And why not these same 3 lawyers were selected as well for A1 and A2. And my lord, it is in fact from A1 and A2's own submission that they declined to meet these lawyers. Nor have we got any confirmation of recusal of the other lawyers who are representing A1 and A2. It is the prosecution's prayer that in cases of this nature, the accused persons ought to be represented. And the state has gone ahead to have these lawyers selected, and therefore the need for another week or 2 does not prejudice this case from proceeding with hearing this morning with the prosecution's first witness. We humbly pray that this honorable court be pleased to permit the prosecution present its first witness as earlier prayed.
I'd like to start with the question of the delay in this case, which keeps on coming from prosecution. since they don't tire, repeat a pretense that they want this to be solved quickly. I cannot tire, or we cannot tire, in reminding prosecution why this case has delayed. The cause is entirely the state. From the months we spent in an illegal court of the court martial, it was the state taking us there. From the time the court martial was conclusively dismissed, I went on a hunger strike. I nearly died in order to be brought back to court. We were in limbo. Up to now, people who were charged by the court martial that was conclusively declared unconstitutional, they are still with us in Rosira, have not appeared before any other court, are not under any remand of anybody. They are in limbo. If I hadn't gone on hunger strike, we would be like those. Hundreds who are still in Rosira, held by the court martial that was declared unconstitutional. Some are even now being taken back to the current court martial.
Kindly submit for your case. That those ones also will submit this case before the
Really,
that one also.
so the delay
Yes.
in our case has been occasioned by the state. They were supposed to give us disclosures last year. Even on the, was it the 15th, when we were last year, they gave us the last disclosure. They said they had finished the disclosures. They gave us 2 while we were here in the last court. And they told the court so, that they had brought in disclosures. Seven months later, the time we spent under the application of hiding witnesses' identity was not our making, it was their application. We want to get out. All we ask is that the process should be fair, not just fast, but fair, as required by the Constitution. Having said that, sir, the state-funded lawyers is an entitlement in capital offenses where the accused cannot have a lawyer of their own choice. Even in the Constitution, it is 28(3)(d), which gives the accused the right to get a lawyer of their choice. Following that, E And that sequence is for a purpose where that legal representation is not available of your choice. You are entitled to one by the state. That interfered with them, arrested, tortured, deported. It is the state. And that's why we insist on solving that problem through our application 248 as the first priority. But having said that, sir, I would expect prosecution to be familiar with the rules that relate to state-funded lawyers. That's statutory instrument 55 of 2022. In Rule 13 of those rules, which is about duties of state-appointed advocates. Sub-Rule 4 of Rule 13 says a state-appointed advocate shall B. Provide written confirmation to court that he or she has met their chosen person within 2 working days after the meeting. And more importantly, C. Submit to court a certificate of trial readiness within 5 working days before the hearing of the case in the form set out in Schedule 2. So if these were our lawyers, we have to meet, we have to consent to them being our lawyers, which is also part of the rules. And we have to prepare for the hearing. We just don't turn up on the witness. Of course, Rule 14 says that at the first hearing where we are not yet, the accuser has to confirm to court whether he accepts or rejects the state-funded lawyer. But in all this, I'm saying, even if lawyers of the state were to be appointed, there is a process before we can be ready for hearing. The court has been told many times before about the voluminous nature of the disclosures which we will have to go through with our lawyers, either our preferred lawyers or state lawyers, whoever they are. We will need still time and the facilities which we have been through, go through the disclosures and be ready for trial. Lastly, sir, I wish again to draw your attention, sir, that I wish to draw your attention again to the application for stay of criminal case number 355. Pending our appeal and miscellaneous application number 227.
Number
227. We hope that that application too will be heard by the court. Before hearing the case take place. Thank you, sir.
In his ruling, Judge Emmanuel Baguma dismissed Besigye and Hajobed Lutare's submissions. He ordered the trial to proceed, beginning with the swearing in of court assessors, despite objections from Dr. Kizza Besigye.
There is one law firm which had a courtesy to notify court that they decided to withdraw the instructions. This law firm is a root of advocates. They wrote and notified to this honorable court on 8th July, and it was received on the same day. It's very clear that this law firm indeed followed the process and the best practice as officers of court to notify this honorable court their withdrawal. I want to note that while the accused person said other lawyers apart from Karua, who was deported and who is in prison, I want to note that other lawyers whom I have mentioned have never at any given point as officers of court notified this honorable court that instructions were withdrawn from them or they have ceased to be lawyers in this case. I'll go ahead and state that still court went ahead and advised the accused persons that assemble those accused persons who were not deported or arrested to come and participate in this case. Right? But the accused persons keep insisting that they are intimidated. But from court record, apart from what I'm hearing from the accused persons, these lawyers whom I have mentioned have never notified the court such intimidation or withdraw from this case. Court went ahead to advise and explain that for the interest of justice and for a fair trial, The accused persons were given a list of lawyers, 726. I'm happy that accused persons have told the court that they have looked at them. So far they are at 227, from whom they intend to select from. But in alternative, and for the interest of the time these people have been on remand, for the interest of the fair trial, the court had given third option. This third option was the court's register to appoint 3 lawyers on each A3 who went ahead to give the legal instructions. This has been confirmed indeed by A3, who has told the court that the team of state briefs will represent him together with his other 2, and the court has no problem with it. Now, the reason is given by the 2 accused persons, that is A1 and A2, that this case should wait for the disposal of the first application number 248. In my view, this application is before a different judge. I can't control the matter which is before another judge. But be it as may, this court still can respect the outcome of that case at any stage. I have no problem with any outcome of the application, and the court indeed will respect the outcome. But this court cannot wait another case. That case is not a bar of this one. I have also listened that there is an appeal lodged in the Court of Appeal in another decision before me. Still, this appeal can go ahead. There is no bar that at any stage the proceedings can stay. But matters must proceed. I explained the constitutional right, a fair trial, right to a fair hearing, also provides under clause 3E that an accused charged with any offense which carries a sentence of death or imprisonment for life be entitled to legal representation at the expense of the state. It is my view that this court has no right to deny the accused person this entitlement which is provided for in the Constitution. By this provision, the legal representation provided by court, that is where 3 lawyers were appointed on state belief, shall remain in fulfillment of this provision. The accused persons remain entitled to add any other legal representation of the accused at any stage of the proceedings. Courts cannot dispense with this provision of legal representation in cases of capital nature. Therefore, I want to confirm that this honorable court is not imposing lawyers to the accused persons whatsoever, but it is a constitutional requirement of legal representation as per the Constitution, Article 28, 3E. Therefore, the 3 lawyers on state brief shall remain in fulfillment of this provision. The accused persons are free at any time to add other lawyers or to deal with the lawyers on state brief. Having said that, I will now proceed to present the assessors who were chosen and given to the parties for the purposes of taking the course. This is another opportunity to you, Doctor. I want to hear from you that if you are given opportunity right now to meet the lawyers on state brief and the assessors, I think we are not watching a football match. We are in court. I am appealing to the public, the people in this honorable court, that you must provide a conducive environment in this court. I'm asking you, Doctor, that if you are given opportunity to meet now, these lawyers make history, they have disclosure, you incorrect had a disclosure. I'm asking you as the last chance, that would you mind meeting them, given some time, and then with the assessors whom you accepted that you got the list, would you take that offer to give you some time in the court here? And if it is a different court code, can give you a different court code and we agree on the time to meet them and then we come back here. What is it?
I still have a problem with that. I actually have a problem with that. Because, like I pointed out, even if these have been appointed to be our state-funded lawyers, the laws provide the process through which they become. They don't instantaneously become because they have been appointed. And I refer this court to their rules. It's that Instrument 55, 2022. So, before using them to achieve purposes on our behalf, we would have to first of all meet with them and establish whether we consent that they become our lawyers. Which is a process that we would be open to. But even before that happens, to now say meet with the assessors and let the lawyers dispute, now establish the suitability assessors. Again, it's clearly not in line with the dictates of fair hearing. So if the court so feels, it can go ahead and appoint them without our participation. But I cannot participate when my eyes are tied, closed. I have to participate with free hands and free eyes and mind.
We don't fear to be tried. But what we are looking at, or we want in this temple of justice, is fairness. So I cannot associate myself with the assessor whom I don't know. That's all.
Besigye and Besigye Lutale protested the appointment of the court assessors. Judge Emmanuel Baguma directed the prosecution to call its first witness.
I will not stay in this hopeless court. I will not. You can continue to find me in my absence. I will not continue with this criminal record.
Whether you stay, whether you want to listen or not.
I will not stay. I will not stay. I will not stay. And if I stay, you will not record. These criminals cannot come and take over our country. You will not conduct the court.
The prosecution first witness, Andrew Wilson, an American investigator, then took the stand. As the witness began giving his evidence, Dr. Besigye loudly protested, urging the court not to proceed and alleging that the trial was unfair.
I will not allow it, Mr. Baguma. No way! No way! No way! We shall not allow this nonsense. It's not allowed. You have abused our country now. You have abused our country now. Stop it, you. Stop it.
No.
I will not allow you to continue abusing our country, abusing our constitution, abusing the laws. I will not allow you in your final week. I will not allow you.
If you don't want to sit,
I
go out.
No.
The other people. Court order. Whoever doesn't want to sit, then go out.
We will not allow this. We will not allow this. Don't tear my papers.
Don't want to sit. Court order is going to
Stop it. You can take me out, but you will not keep me here. I will not keep you quiet.
Those papers.
No way. You can take the papers. They must take my mouth also. My mouth will continue talking. I will say you are raping our constitution. You are raping our courts. You are raping the law. We shall not allow this. It has to have a stop. It has to have an end. It has to have a stop. We shall not allow it. Oh, we shall not allow it. Yes. I will make an alarm for the whole country to know what is going on here. This nonsense must stop. 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 You can handcuff me, but this nonsense will have to stop. You must close my mouth if you want. I will not keep quiet. I will not keep quiet. I will not allow this nonsense to continue. I will not allow this nonsense to continue. You will not.
The hearing continued despite repeated interruptions, with Dr. Besigye shouting and banging on the door throughout the whole proceedings.
This nonsense. It will not continue. No, 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 no. 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 Wa-la-la-la-la-la-la. Wa-la-la-la-la-la. Wa-la-la-la-la-la. Nonsense, nonsense. Wa-la-la-la-la-la. We cannot allow this. We cannot allow this. We shall not allow this. We will not allow this. We are not going to allow this. Nonsense, nonsense, nonsense.
Tension escalated when the witness was asked whether he can recognize any of the accused persons, and he identified Dr. Besigye as one of the persons who approached him with a plan to overthrow the Ugandan government. Dr. Besigye intensified his protest, continuing to interrupt the proceedings.
Continue writing the constitution to establish a constitution. We went to war to fight for the constitution. Then right now,
in this court of Mr. Waguma. We shall not allow it. We shall not allow. You are injuring me, you prison's man. You are injuring me with your handcuffs. You are injuring me. You are injuring me. You are injuring me. Why are you holding me? Why are you holding me? I am in court. I am not violent.
Despite the disruption, Judge Emmanuel Baguma allowed the prosecution to continue leading its evidence. Later, while still expressing his dissatisfaction with the proceedings, Dr. Besigye, who was wearing a mask, collapsed in the dock, prompting the judge to temporarily halt the hearing. He was later escorted from the dock to the court cells before being taken away by ambulance about an hour later. Outside the courtroom, some of Dr. Besigye's supporters attempted to confront court orderlies and security personnel who prevented them from accessing the accused persons. The court adjourned the matter without announcing the next hearing date in open court. However, court sources later indicated that the trial is expected to resume tomorrow on 30th July 2026.